Welcome. My name is Deborah Buford. I am the Manager of Employee Accountability and Partnership in Labor Relations here at the U.S. Office of Personnel Management. Our office presents roundtables in support of our ongoing effort to bring relevant and reliable developmental opportunities to federal sector employee and labor relations practitioners. It gives me great pleasure to welcome you to today's roundtable entitled MSPB Case Law, Lessons Learned from the Most Influential Decisions. Today's presentation will provide an overview of significant federal case law encompassing the most influential decisions that shape considerations impacting adverse and performance-based actions. Today's session will cover topics such as drafting charges, penalty selection, nexus, credibility, due process, security clearance determinations, and other matters. I encourage each and every one of you to make the most of this roundtable, including asking questions of our presenters. You may do so by sending an email to employeeaccountability@opm.gov. We will do our very best to field as many questions as possible. Please note that shortly following the presentation, everyone who registered will receive a hyperlink to an online evaluation form courtesy of surveymonkey.com. Simply click the link, follow the instructions, and your valuable instant feedback will be sent back to us. Your feedback is important to us and helps us to plan future roundtables. We are pleased to have as today's speakers Mr. Michael Bogdanow and Administrative Judge Ronald Weiss from the Merit Systems Protection Board. Mr. Bogdanow is the senior legal liaison between headquarters and the Merit Systems Protection Board's 8 regional and field offices. Administrative Judge Ronald Weiss brings to us his extensive experience as an adjudicator of appeals made to the MSPB. They both work in the Office of Regional Operations at the Merit Systems Protection Board. Please join me in welcoming Mr. Michael Bogdanow and Administrative Judge Ronald Weiss.
Well, thank you very much, Ms. Buford. And thank you to OPM for having us, and for all of you who are out there on the webcast for allowing us to spend some time with you. I must admit that when we first received the announcement about this program, we were kind of cowed by the degree to which we would have a large amount of subject matter to cover. Best practices and decisions and responsibilities of the board, all of that will be covered. Just to cover very briefly what the board's responsibilities are, it won't come as any surprise to hear that our biggest responsibility, really, the one that takes the most of our staff, is adjudicating appeals from federal employees and applicants. In addition to that, we have a very large studies function, which writes all of the studies that you frequently hear about and see of interest to the federal government. And third, the board also has the authority to review the significant actions of our host, OPM. But we will not be talking about that. We're going to confine ourselves to the appeal process and to MSPB significant decisions. Picking significant decisions out of 36 years worth of precedent is a somewhat difficult task. It's kind of like asking a parent to pick his favorite child, except I don't know a lot of parents who've had children for 36 years and have several thousand of them to choose from. So what we've tried to do is to give you cases from which you can learn a lesson that we hope will help you in adjudicating cases before the board. And we hope that from those cases, you'll be able to relate others that relate to other cases that will also assist you. The way we're going to do this today is that we've more or less divided this in half. Ron will be presenting the first part of this. I'll be presenting the second, but each of us has given permission to the other to kibitz while the other one was going on. So hopefully we hope you will find it helpful. And with that, I'll turn it over to Ron.
Okay, good afternoon. I'm going to take us to our first slide here, which is sort of a soup to nuts rundown of the steps that a typical case would go through. Obviously, we're not going to spend a huge amount of time on every step, but I think what we'll try to do, at least in the first part of the presentation, is as we move through these basic aspects of a case, we'll be flagging the major cases, the important cases that Mike was talking about, so you can see how they fit in to the overall process. So, and some of this may be basic and review for you, but we'll hopefully get into the more complicated issues as we go along. So just to review, the case starts when the agency takes an action against an employee. The employee then files an appeal, which lands at the MSPB. We then go out with our acknowledgement order, which has certain imposes certain responsibilities on the parties. The agency has to file a response file within a certain amount of time. Deadlines are set for discovery. If there are any jurisdictional or timeliness issues, those are flagged in the order. There may be a schedule set up for settlement discussions. Barring a settlement, there will be and if there's been a hearing requested, there will be a pre-hearing conference in which the parties will have to file pre-hearing submissions beforehand. The hearing will be conducted, and an initial decision will be issued. Now, to back up at the start, for the part that happens, before we get involved, but is of crucially importance to agency representatives and human resource departments, is the process of agency taking an action. And this is sort of a breakdown of the things that an agency typically has the burden of proving. The agency has to prove its charge against the employee. The agency has to prove that there's a nexus or a relationship between that charge and what's called the efficiency of the service. The agency then has to prove, if they've succeeded in proving those first two things, the agency then has to show that the penalty that's been selected is reasonable under the circumstances of the case. And we're gonna talk about each of those steps. But let's back up again now and talk most pointedly about charges and the pitfalls, the hazards of putting together a charge. And many of you may be familiar with some of the most common ones. But let me start off by saying that there's basically three aspects or three parts to a charge. One is the label of a charge, what the agency is calling the charge or characterizing the charge as, or whether the agency is even deciding to put a label on a charge. The next thing is the specifications of the charge, which is how, the particulars, the sort of who, what, when, where, and why of the charge. So, for example, if the charge was AWOL, absent without leave, on what dates and for how long, those would all be specifications of the charge. And then what may be the sort of subtle and tricky part of the charge, because it's invisible, is the elements of the charge. What is the agency going to have to prove? And sometimes those elements are can end up being tricky because of the other aspects of the case. So, for example, what charge the agency has selected. And there are basically three kinds of charges. There's the specific charge, something like I just mentioned, AWOL, something like insubordination, threat, falsification. These are all charges with well-known definitions, often coming down from the common law as to what elements have to be proven to sustain a charge like that. So right off the bat, you have to be aware that if you're going to bring a charge like that, then you're going to have to be prepared with the evidence to back up those elements, which isn't necessarily a reason not to use a charge. If the evidence, if the facts fit the charge, then most likely that's the best way to go, is to use one of those specific charges. Everybody knows what they mean, and oftentimes if they are proven, they may justify a more significant penalty than one of the other kinds of charges. The second kind of charge might be deemed a general or generic charge. That's something like improper conduct or conduct unbecoming a federal employee. Something where you know that something bad has happened, something allegedly bad has happened, but you don't know what it is from looking at the charge itself. You're going to have to read on further. You're going to have to look at the specifications to find out exactly what the agency means by that. Then a third type of charge doesn't even have the generic label to it. It's what's called a narrative charge. And the board will have to determine from reading how the agency has described the charge as to exactly what the charge is. And I think I'm going to skip to the next slide. The case of Otero took up the question of, is a narrative charge like that, where there's no description of the charge, is that permissible? Or is that in some sense a due process violation because it's too vague for the employee to even respond to? I think the employee in that case argued that I don't even know what it is that I'm being charged with specifically. And the board found no. Narrative charge is permissible. It does not by itself present any kind of due process problem. But that leaves open the question of, just because it's permissible, that doesn't mean that an agency necessarily is wise to go down that road. You're one thing to bear in mind is that to the extent that that an agency does that, you're giving an awful lot of discretion to the board to decide exactly what your charge is. And there could be something in that narrative that takes the charge in an unexpected direction. One thing that might happen is the use of what might be called a loaded term. So, for example, if somewhere embedded in that narrative, the agency uses the word, the employee acted in a threatening manner, for example, that word threat it raises some flags, and should that use of the word threat then turn the whole charge into the charge of making a threat, which has a very defined, again, set of elements that have to be proven. And if that's not what the agency set out to do, they could be caught unprepared. So I think most judges at the board would advise against using the narrative charge, even though you're permitted to do it. The other issue that we've talked about already is that the elements, all the elements of a charge have to be proven. So, for example, in this King versus Nazelrod court case, the charge was threat, and because it was threat, the question arose: what does the agency have to prove? Does it have to prove the common law elements of threat as they come down to us? I mean, not threat, theft under the criminal law. One of those elements is not that you took the property of another, but that you had the specific intent to permanently deprive the rightful owner of that item. In other words, you weren't going to take it and give it back the next day. And in Nazelrod, the facts didn't really bear that out. There was clear evidence that property had been misappropriated, but there was not proof that the employee intended to permanently deprive the government of that property. And the court found that yes, the elements of theft from the common law, all of them have to be proven. And since the one of permanently depriving was not present, the whole charge fell. Now that's a situation where the agency clearly could have disciplined the employee for something. Maybe they could have brought a charge of misappropriation or just improper conduct or misuse of government property, any number of things. So that's an example of one of the things to keep in mind about elements. Another issue arises in the Burroughs case, also a case from the Court of Appeals for the Federal Circuit. Again, this emphasis on what are the elements of the case and the fact that all of them must be present before a case can be sustained. So in Burroughs, the charge was directing the unauthorized use of government materials for other than official purposes. And the board found there, and the court found that all of that aspect of the charge has to be sustained. So the agency had to show that there was an unauthorized use of government materials and that unauthorized use was for unofficial purposes. And the facts of that case ended up establishing that although the employee had acted without authorization in using certain government materials, it was for official purposes. It wasn't for his personal use. He just wasn't authorized to be doing it. And since the way that charge was defined, all the elements had to be sustained, and so the whole charge fell. Another way to think about this is that the board is not going to sustain lesser included charges that may sort of lurk within the charge that the agency actually brought. We're not going to sort of fix it for you if you didn't break the two charges apart and charge them separately. We're not going to do that for you. And we're not going to say that, well, within the charge that the agency actually brought, there was a subset that has been proven. That's not something that the board is authorized to do under our case law. So again, it's something to bear in mind as to how you put the charge together. And in general, the simpler and more concise you can make the charge, and if you can break them down to sort of bite-sized chunks as opposed to running things together, the safer you're going to be. A corollary to that is what happened in this Greenow case, and this points up a particular kind of hazard, which is the use of conjunction or connecting words like and. So, for example, the charge was making threatening remarks about your supervisor and coworkers and using inappropriate language. Now, is that two charges or is that one charge and in which all the elements have to be proven? And there's nothing wrong with, in theory, putting and between two separate charges. And if the board determines that the charges really do arise separately and are not dependent upon each other, then the board will allow the agency to characterize the charge like that, and proving one won't necessarily be dependent on proving the other. But in Greenow, they found that was not the case, that this arose from a single event, and that charges couldn't be broken apart, and so the agency was going to be tasked with proving all of it. And the first part of it, making threatening remarks, again raises the classic charge of threat, which has certain specific elements, including intent elements, that would not have been necessary to prove using inappropriate language, which is the last part. But just when you think you've got a handle on what is or isn't going to be two separate charges, there are other cases that sort of muddy the waters. There's another case called Fairley versus U.S. Postal Service, 63 MSBR 545. The charge there was pushed subordinates and threatened them with physical harm. The board there found that those were two separate charges, pushing and then threatening, and the agency could try to prove them separately. So I'm not sure, looking at Greenow and Fairley, whether even I can tell what the board's going to do in those situations. So it's better just to stay away from the use of the word and other things that are also problematic, the use of adverbs, like, the employee continuously, or the employee excessively. I mean, what does excessively mean? Is twice, 3 times, 4 times? It's better not to create problems of definition that way, if you can, bear that in mind. And there are a host of other equally vexing charging issues that we could talk about. In fact, we could expand this program on nothing but charging pitfalls. But I think you get the sense of how critical some of the language ends up being with charges. So I think that's enough for us at this point.
Yeah, if I could
Sure.
just add one point. The choice of how to make a charge is entirely up to the agency. You have a huge amount of control before you bring an adverse action over just how it's going to be decided. Obviously, the way in which the charges are worded is a huge part of it, but the other part is please make sure you don't come up with your charge before you know all the facts. Agencies have to do an investigation beforehand so that they can charge correctly. And when it comes to choosing the way in which you want to set out the charge, as Ron said, if you choose to set out just a very lengthy narrative without a set of a specific charge name or without labeling something that has elements, that's fine, but then you're giving up some control because it's the board that then decides what you really charge the appellant with. So, I mean, I think those are the two big points is, number one, make sure that you know that you can prove what you're charging, and number two, make sure that you charge it as carefully as you can so that you can actually end up proving it.
Right. All right, so let's assume that the agency has successfully cleared that minefield of putting the charge together in such a way that it's clear, that it matches the facts that the agency intends to prove. What's the next burden that the agency has? Well, that's called Nexus, which is really just a fancy way of saying that there has to be some connection between whatever conduct is being charged and the concept of efficiency of the service. And one thing that threshold issue that it's important to bear in mind is we're not talking about whether the penalty fits the crime, so to speak, or whether the penalty is reasonable. That's a whole separate determination, something that the agency also has the burden of, and we're going to talk about in a minute. But with Nexus, we're just talking about whether this is something that, even if the conduct is sustained, is it something that the agency should be concerned about in terms of its mission and its ability to perform whatever duties that it's charged to perform. And in practice, we're talking about issues that arise on off-duty. So off-duty misconduct that the agency wants to discipline. And then the issue arises, well, are things that the employee is doing in his or her private life, does that rise to the level of something that impacts the efficiency of the service? This case, Kruger, was one of the formative cases that talks about what those factors are and considering whether Nexus has been shown. Let me talk about the second two issues there. One first. One is that a showing that although the misconduct may have been off duty, it nonetheless affects the employee's ability to carry out his or her job, or his coworker's ability to do his job, or it affects management's trust and confidence that the employee is going to be able to continue to do his job, or that the misconduct interferes in some way or adversely affects the agency's overall mission. Now, the agency doesn't actually have to specifically prove that these things have already happened, that there has been an adverse effect on the mission or on the work performance. Otherwise, the agency would have to wait until it's actually happened before bringing the charge, and the agency is not required to do that. The agency is allowed to say, look at what happened in this private life. Now we can't have him anymore as an employee. So it's sort of, they have to make the argument that it potentially will do these things. And then there's a third category, sort of a catch-all. There's a rebuttable presumption of such nexus in the face of what's called certain egregious circumstances based on just the nature of what it is that's being charged. This sort of reminds me, and I know some of you may remember from an old Supreme Court case when the Supreme Court was trying to decide what constitutes obscene, or what is obscenity. It's sort of a difficult concept to define. And former Justice Potter Stewart said, well, I don't know what it is, but I know it when I see it. So it's sort of the same way with what is egregious, sufficiently egregious that triggers this presumption. It's hard to say. And you can look at some of our previous case law on that. It's something that's really shocking to the conscience, so that the agency shouldn't even have to tie it to a specific performance or mission issue. But aside from that, those egregious circumstances, whatever they are, the agency is going to have to make some kind of a case that the private misconduct has a carryover effect onto the workplace. One case that was relatively recently, it was called John Doe versus Department of Justice. It went all the way up to the Federal Circuit. The site there is 565 F. 3rd, 1375. It was a case of an FBI agent who, it turned out, was taping various sexual encounters that he was having with coworkers, unbeknownst to them. And although actually the first employee allegedly knew about it, and they were in a relationship, and it was through the course of when she discovered that she wasn't the only one in his file of tapes, she in trying to work through the effects on their relationship, apparently she had some counseling with the agency's EAP program, and at some point it got out to everybody else in the office. The initial case was heard before an AJ, administrative judge, who found that there was no nexus here. This is private conduct. The agency had thought that it was a criminal offense to do that kind of taping, unbeknownst to the other participants. But it turned out, I believe this was in Ohio, and under Ohio state law, it wasn't actually against the law, although in other jurisdictions it is. So the agency was incorrect in relying on the fact that it might have been criminal behavior. And the AJ found that there was no other, that this wasn't so egregious to trigger the presumption, and they weren't able to show these other factors. The board disagreed and found that there was, and based it on a finding that this was clearly dishonest conduct, especially for a law enforcement official, and that's what provided the nexus, the link. It went up to the U.S. Court of Appeals for the Federal Circuit, and they disagreed yet again, and they found that where did this clearly dishonest conduct standard come from, and what did it mean, and that was nebulous and vague enough that no employee would necessarily know what was in or out of that definition. And that's bad enough for an employee not to be put on notice as to what conduct is or isn't actionable. The other potential problem the court pointed out is if you have some kind of vague catch-all like that, the charge could serve as a pretext for some other prohibited reason why action is being taken against this employee. So they remanded to the board to come up with some system or some greater guidance as to explain what the board meant by this clearly dishonest standard that they had raised. And the board said, well, never mind, we're just going to go back to the Kruger standard, the ones that have already existed for many years. And under those criteria, the board said, well, clearly there is a connection because these were at least some of these people were his coworkers. And obviously there could be, and there was, a good deal of turmoil in the office because of this, which did impact the agency's mission and did impact the ability of the employee and his coworkers to perform his job. So there was the nexus. And we'll have a little bit more to say about Mr. Doe, the FBI agent, in another category based on the fallout of what happened after that. But Mike, you want to add anything about nexus?
Just to give you an idea of the kind of charges that the board has found create this rebuttable presumption, they truly are egregious kinds of things. The I guess most frequent example is a child molester, somebody who's been charged with the criminal act of child molestation. The board has always found that that raises a rebuttable presumption. And with respect to the misconduct interfering with the mission of the agency, perhaps the best known of those was a case from several years ago that the Federal Circuit had decided called Weston versus Housing and Urban Development, where a gentleman who indeed worked in a fair housing program was a slumlord. And the board found clearly that that was inconsistent with the agency's mission. And so, and the court, and that action got reversed on, there was a finding, of nexus on that basis. And is there a question out there?
Yes, we have one question. It's dealing with nexus.
Okay.
A police officer was charged with larceny after coming on board with the agency. He did not inform the agency of the charge. The case went to court and was dismissed. Can the agency use this act to remove the employee?
So the underlying case, in the criminal case, was dismissed against the employee, I take it from that example. Well, that raises a couple interesting issues. I mean, as I mentioned, if there is criminal conduct, even if it's on off-duty, that will often establish the needed nexus. Now, in this case, it sounds like the criminal conduct was not sustained. However, there might be the charge of lack of candor or falsification of the employment application, which, regardless of the fact that the employee may have prevailed in his criminal case, if he was required to answer in a certain way on his application about this history and he didn't, then there would be no nexus problem with a charge arising that way.
Right.
Want to add anything?
And there's also the fact that just because a criminal charge cannot be sustained doesn't necessarily mean that a civil kind of charge couldn't be sustained. Criminal charges obviously have very specific elements and have to be proven, by a much higher standard of proof. So an agency can take a chance on charging the conduct underlying what was the criminal charge. And for a police officer, any kind of criminal charge it's reasonably easy to find nexus. So whether the charge can be sustained or not is another story, but a finding of nexus on either a lack of candor or on the underlying sort of criminal misconduct is probably very doable.
Right. I mean, it's probably not so much a nexus issue under those facts. And most cases are not going to present a nexus issue. We're really talking about some sort of rarefied examples here. But I think that the larger question is going to be, can you sustain the charge if it got overturned in the other case? But as Mike pointed out, the burdens of proof are different. So it's not necessarily the fact that just because the state couldn't prove it beyond a reasonable doubt, that doesn't mean that there isn't sufficient evidence to prove it by preponderant evidence.
One more question. Can you review what the standard is that provides an agency with a reasonable cause to believe that an employee may be imprisoned and thus an indefinite suspension is warranted? This person is saying, I don't believe an arrest alone enough, but is the filing of an indictment an absolute enough act?
Yeah,
Any
the
guidance?
questioner is right that typically the mere arrest isn't enough, but the indictment typically is sufficient, or sometimes they call it an information. But yeah,
The answer actually depends in large measure on state law, because depending on the criminal process in that state, if a criminal information can be issued on very little in the way of evidence, it's entirely possible that the board is going to find that that's not sufficient, and the agency is then going to have some additional information that supports it. But remember that it isn't just the criminal charge that can be taken into account or will be taken into account by the board. The board will also take into account other information that the agency had in front of it at the time that it decided to indefinitely suspend. And so it's entirely possible that even if the criminal charge isn't sufficient on its own, the agency can make up for that.
Thank you.
Okay, well, let's assume that we've cleared Nexus also, or that Nexus never really was an issue in the case. The next thing that an agency is going to be tasked with proving is the reasonableness of the penalty that they've selected. Now, typically, the choice of a penalty is within the discretion of an agency, and the board is supposed to extend quite a bit of deference to an agency's selection of penalty. Obviously, the agency has much more knowledge about its mission and what the impact on that mission might be of a given offense, and the board is not supposed to substitute its own judgment. The standard, though, is whether the agency has exceeded the maximum reasonable penalty under the circumstances of the case, and only then should the board step in and possibly mitigate with another penalty. And what are those circumstances? Well, typically they're viewed under the famous Douglas factors, and here they are listed for you, the 12 factors. There's going to be some discussion of Douglas factors in probably every adverse action case, which doesn't mean that all of them are necessarily applicable in every case. There may only be some that are of particular relevance, and the agency shouldn't feel like they have to mechanically and by rote go through every single one and explain how every single one did or didn't play into the selection of a penalty. But there should be some consideration as to which factors really did play a part, and then those should be explained. And all the factors aren't typically as weighty as each other. Clearly, the first one, the nature and seriousness of the offense, will, in almost every instance, be the most significant consideration. But the others may play important parts as well. One thing to remember, though, that there does have to be some kind of analysis. So to the extent that the board gets the impression that it was done mechanically, or that there was just sort of a sense that this penalty always follows from this kind of offense, then that's a way for the agency to lose the deference that it otherwise would be entitled to. For example, I don't know if it's used so much anymore, but for a while there was a vogue for zero tolerance language. The agency has zero tolerance for drugs in the workplace or violence in the workplace, which is commendable. But if the outcome of that is that because of that zero tolerance there must be removal, then it sounds like the Douglas factor analysis has been short-circuited, and that's an easy avenue to lose the deference. Some of the other ways to lose the deference is when these factors are considered but in the wrong sort of way. So, for example, past work record, typically that's a mitigating factor if the past work record is lengthy. So if somebody has 20 years of service and this is their first misconduct, that would typically be a mitigating factor. It doesn't necessarily mean it would be a decisive one, but it's appropriately viewed as a mitigating factor. If an agency were to say, well, this person's been here for 20 years, he should have known better, or we're treating this even more severely for somebody of his seniority to have done something like that. That's an indication that instead of being used as a mitigating factor, it's been used as an aggravating factor. Again, that might be grounds for losing the deference that the agency would otherwise have. That if they lose the deference, that doesn't mean that the penalty is necessarily going to be overturned. It's just that the board will then, at least theoretically, not be limited to deciding what was the maximum reasonable penalty, but could decide for itself what they think the right penalty would be. Another one of these factors that used to be sort of less significant but has kind of risen in importance in recent years is the consistency of the penalty. This is in large part because of this case Lewis, which is summarized there. It used to be that the consistency of the penalty, or another way to talk about it is that whether a penalty was disparate, was sort of, it was there as a Douglas factor, but it usually wasn't decisive, in part because in order to show disparate treatment for penalty purposes, you had to identify a similarly situated employee who was treated less harshly for similar conduct. And in order to qualify as similarly situated, the circumstances had to be almost exactly the same. So you had to be in the same position, working for the same supervisory chain. The conduct had to be very similar. It was very mechanical. And if you couldn't meet those pretty strict requirements, then it didn't matter if somebody else was treated differently. And then even sometimes when those requirements were met, the board would say something like, well, even if there was disparate treatment, if the penalty in this case is otherwise reasonable, we're not going to overturn it just because of that disparate treatment. Well, that analysis has changed quite a bit. And what emerged from Lewis is that although some of those factors of whether you're in the same supervisory chain, whether you were in the same position, those may be relevant factors, but they're not going to be hard and fast rules. They're just guidance. And so even if somebody was working in a different shop at a different location, if they and the standard is, is there enough similarity between both instances or multiple instances to lead a reasonable person to conclude that the agency treated similarly situated people differently, and that's kind of a more again, it's not a clear, bright line rule. It's more of a vague sense that the circumstances were similar enough, then the agency is going to be put to its proof in a sense as to, well, what's the explanation? Come up with an explanation. There may be a good explanation as to why circumstances were different, but the agency likely is going to have to come up with one, and if they don't, it may well turn out to support a mitigation in the case. Interestingly, there's a parallel analysis that takes place in claims of discrimination. One of the ways of proving discrimination by circumstantial evidence is through a disparate treatment analysis. That, in other words, the employee is a member of a protected class, and another employee not in that protected class engaged in similar conduct and was treated less harshly. The board specifically said in Lewis that they were not changing the previous analysis of similarly situated employees for purposes of the discrimination claims. So in those kinds of cases, in that context, you're still going to have to, an employee would still have to show that the similarly situated employee was virtually identical to the appellant's case. Want to add anything to?
No, it's an odd juxtaposition when you think about it, that the test for proving something as significant as discrimination is harder to meet than is the test for simply proving disparate penalties. But that is the way the case law breaks out. So keep that in mind when you're trying to defend against an appellant's affirmative defense.
Right, and another common Douglas factor that may have a significant impact is whether there was prior discipline in a case. Clearly, an agency is entitled to progressive discipline, and so if they've already disciplined someone in the past, say, for example, AWOL, and they suspended them or reprimanded them, and now it's happening again, especially if it's happening over a short period of time, the agency may well now be justified in jumping to removal or a more serious offense based on the prior discipline. And the board has developed some case law as to how to treat the prior discipline. The principal case is this bowling case. And the thought here is that the board doesn't want to sort of get dragged into a trial within a trial where the allegations and the circumstances of the prior discipline now become litigated alongside the present dispute. I mean, usually we have our hands full just with what's at issue in the present appeal. So the board's standard here is that where the prior discipline was made a matter of record, was put in writing, and the employee was given a chance to appeal that prior discipline to a higher level of authority, and where the agency is going to have to document that in the record. But where the agency is able to show that, the prior discipline is available to be used as an aggravating factor in the current case, and the board is not going to look behind and is not going to entertain an employee's allegations that that prior discipline should never have been issued or it wasn't true and so forth. The only caveat is the board will review whether the prior discipline was what's called clearly erroneous, and that's a little bit misleading. It doesn't mean that the prior discipline should not have been broad or was not sustainable. It just means that if the appellant can show that there was like some incredible mistake of identity, it wasn't even issued to the right employee or something along those lines, then perhaps it could be set aside. But barring some extreme situation like that, as long as the agency satisfies those bowling criteria, then the prior discipline will get to be used. Now, clearly, there's some other hurdles there. If there's a collective bargaining agreement which says that prior discipline will be expunged after a certain period, then the agency will be bound by that. In general, the older prior discipline is, the less weighty and significant it may be deemed to be. And also, I think in general, the more similar the prior discipline is to the present charged conduct, the more significant it may be. But any prior discipline may have an effect, and it may bleed over into one of the other Douglas factors, which is the fact that the employee had notice that what he's currently being charged with was not acceptable to the agency. So obviously an employee couldn't be heard to say, well, I didn't know that the agency was going to be so upset about this, when you've already been specifically disciplined about that once. One little wrinkle that has come up, and it resulted actually in a Supreme Court case, is this Gregory case. The question was, well, what if the prior discipline is currently the subject of a grievance? Should the agency be entitled to still use that? And no less than the Supreme Court said yes. Even if that grievance is still pending, it can be used. Which sort of raises a question of, well, what if down the road the grievance is successful and the prior discipline is overturned? What happens then? I'm not sure that I specifically have seen that scenario, but if the case at that point was on PFR, then that would be a good argument on PFR to say, well, the board, the administrative judge sustained this at least in part, on the existence of prior discipline that's now been overturned. If it's already been a final decision, it might perhaps be grounds for a request for reconsideration. But I don't know. Has that ever come up? Do you know, Mike?
I believe it has, and the question on reconsideration, of course, is not just was it something that the appellant could not have raised sooner, but also is the fact that this piece of prior discipline is no longer something that they can rely on, is that enough to change the result? And although the board will certainly look at it because of its newness, it may not, in fact, still change the result.
Okay, well, another issue that runs through a number of these topics is the question of due process. And it's gotten even more currency based on some recent case law arising from both the board and the Court of Appeals for the Federal Circuit. Let me just review a little bit about what the concept means, at least in terms of board practice. From the Fifth Amendment to the Constitution, there's the concept of you cannot be deprived of. Oh, sorry. There's a question.
Yes, there's a couple of questions on the Douglas factors. Do you recommend providing a Douglas factor analysis in the proposal or decision letter, or just referencing the factors in the notices? Also, would you attach the analysis for full disclosure to the proposal and decision letter?
Okay, well, that is a very apt question, actually, especially for this topic of due process that we're just about to get into. So let me answer that as I get into this, because it runs right into one of the center concerns here. As I was starting to say, due process arises from this constitutional requirement or guarantee that you can't be deprived of life or property without due process of law. And what is due process is stripped down to its basic definition. It's notice and an opportunity to respond. So by consequence of the fact that there were statutory protections developed for federal employment such that the government could not deprive someone of their federal position without good cause. The Supreme Court found that, well, if there has to be good cause and to remove someone from their position, then that position is tantamount to a property interest, and you can't take it away without, again, affording that employee the due process. So that's sort of the jumping off point. So that there's notice, and there's a body of case law as to what sufficient notice is. But more meaningful, I think, for us today is the opportunity to respond, and it has to be a meaningful opportunity to respond. So the question arises is to what does the employee need to know when they are notified that the agency is about to take an action, which is typically the notice of proposed removal or the notice of proposed suspension or whatever the action is. What does the employee have to be informed so that he then has a meaningful opportunity to respond to it in such a way that the deciding official could potentially change his or her position on that proposed action. And this is where the question of the Douglas factors and whether it should be provided to an employee, that's where this comes in. And let me, before tackling that, let me talk about the two main cases here, which you'll probably encounter, which is Stone and Ward. Stone enunciated the principle that if a deciding official renders his or her decision based on ex parte information or ex parte communication, this may trigger a due process violation. Ex parte information, most simply defined, is information that the employee, the appellant, didn't know about at the time of the notice of proposed action. So, for example, if the agency charges an employee with something, and then while the deciding at the stage of where the deciding official is considering whether to sustain the action or not, information comes to that person's attention. Say, for example, that that the employee claimed that he didn't know that there was a instruction from his supervisor, and then the deciding official does some investigation on his or her own and finds a document or talks to a witness who confirms that, yes, indeed, the person did know about that instruction. I was in the room when the supervisor told the employee about this, and then cites that in the decision letter. Well, that's a piece of information, evidence that the employee was not referred to, and thus didn't have a chance to rebut or challenge. Maybe if the employee had known that the deciding official on behalf of the agency was going to rely on that, they would have said, well, that person is lying. I can prove that person was not even in the office on that day or whatever. So under Stone, that would be deemed an ex parte communication that was sufficient to lead to a due process violation. Now, not everything that is ex parte necessarily triggers a violation. The standard is that it has to be something that was new. It was not just cumulative. It didn't just confirm or clarify information that was in fact provided to the appellant, but it was something that was new. And the sense of it is that it's something that was significant enough that it was substantial and likely to cause prejudice, and thus to undermine the sense that the due process was fulfilled. Now, in Stone, this ex parte issue was tied to the question of the charge itself. So in my example, the deciding official was trying to decide, did the appellant fail to follow the instructions of his supervisor? And the appellant had an argument about why that charge shouldn't be sustained, and the deciding official ended up relying on a piece of information, ex parte, that the employee didn't know about. And so he then sustained the charge. For some time, though, the board case law found that if the ex parte communication didn't relate to the charge, but related to the penalty, the choice of penalty, even if it was the kind of ex parte communication that introduced something new. So, for example, let's say the deciding official at his stage determined that there was prior misconduct that the employee engaged in that wasn't cited in the notice of proposed removal, but he or she knows about it. Either he or she personally knows about it, or it came to their attention from some third party. And then that's relied upon in the deciding official's decision. The board in those situations used to find that, well, that was a violation, and the agency is now going to lose that deference that we talked about. But the case would proceed, and the board would just substitute their own determination as to what a reasonable penalty was. In Ward, though, the Federal Circuit said, no, that is tantamount to a due process violation, no less than if the ex parte communication related to the charge. So in either instance now, whether it relates to the charge or the penalty, if it is in fact the kind of ex parte communication or information that leads to the introduction of new information that was significant enough to have prejudiced the whole process, then that's a due process violation, and the entire case has to be set aside. Now, getting back finally to the question that was asked, what about the Douglas factors? Should, for example, a notice include the Douglas factors? Well, the thing to bear in mind is that whatever is cited in the notice of proposed action, that's what the agency is going to be limited to. So if the penalty, if there is a full-fledged Douglas analysis in the notice of proposed action, then to some extent, the agency is immunized from the danger of focusing on a Douglas factor that wasn't already talked about in the notice. Conversely, if the Douglas factor analysis is only done at the decision stage and is not done in the notice, or is not done as formally or as fully, then the agency has opened the door for a ward due process violation. And this might be true even though there are plenty of other factors that would justify the action that the agency wants to take. But if truly there was a factor that a deciding official relied on and is not discussed in the notice of proposed action, then that is a potential problem. Now, does it actually have to be in the notice, or could it be just attached? I mean, there's case law that says that the notice itself doesn't have to be a self-contained universe with everything that the agency relied on. The notice of proposed removal could attach material, including a Douglas factor analysis or other documents. Now, it's the best practice, I think, for an agency to refer to those documents as for our consideration as to why we took this action. In addition to our notice, refer to the documents that we've attached to the notice. I think that puts the agency on pretty solid ground against finding that these things were suddenly reviewed by a deciding official without the appellant's notice. Now, another consideration is even if it was something new and it wasn't cumulative, the due process violation could be cured if there's a showing that the employee knew about it anyway and had an opportunity to respond. So if, in fact, the employee did respond, even if it wasn't in the notice, then that's pretty good evidence that he knew about it and had an opportunity to respond. But even if he didn't specifically respond to it, if there's some other reason to think that he was given the opportunity, and again, it might be because there was other material attached to the notice, then the agency can escape the due process violation. Another way that an agency can perhaps inoculate themselves from this, and there's sort of a terrible incentive in a way that's arisen here. Some deciding official may, in all good faith, want to sincerely investigate whether the charge has been sustained and whether the penalty is reasonable. The deciding official doesn't want to just be a rubber stamp, wants to really sincerely look into it. But by doing that, if he or she turns up something that was not formulated before, then you possibly triggered a stone or ward violation. The best practice in those situations would be to stop then and issue an amended notice or a subsequent notice addressing that new concern and giving the appellant a fresh opportunity now to respond to it. Having done that, most likely the due process violation will be avoided. Mike, anything?
Yeah. No, I think that's absolutely right. It goes back to the first definition that Ron gave of due process, which is notice and an opportunity to respond. So if you have collected new information, then just giving the appellant notice of it and an opportunity to tell you his side of the story on it, that cures any potential due process error, and you don't have to worry about it. These kinds of cases cause a whole lot of consternation for agencies and certainly even at the board, but that is really the way to address them and to see to it that they don't cause problems for you.
Okay. Just briefly, there is a statutory right to a hearing on the merits of a board appeal, but there isn't necessarily a right to a hearing on jurisdiction. So if the administrative judge finds that the employee has not raised what's typically called a non-frivolous allegation, in other words, sufficient facts that if proven, could show that there's jurisdiction. If the employee hasn't raised that, then the board may well dismiss the case without an appeal. However, if there is a non-frivolous allegation of jurisdiction, then typically the board will hold a hearing on the jurisdictional question where the appellant will bear the burden of proving by preponderant evidence that there is jurisdiction. In some cases, that may be together with the issue on the merits. But in some cases, the jurisdictional issue is the entire dispositive issue in the case. So, like for example, in Garcia, when we're talking about constructive action. So, for example, let's say an employee alleges that he or she was forced to retire, forced to resign, or was placed on enforced leave. In other words, forced to take leave by the agency. These are typically considered to be either constructive removal actions or constructive suspension actions. Since if they're voluntary, the board wouldn't have jurisdiction. The appellant is going to have the burden of proving that there was, in fact, this coercive element, or that they were subject to misinformation, and that's why they resigned or retired. So the burden will be on them. But if they were to carry that burden, because that would have been an adverse action or tantamount to an adverse action, without previously giving the employee notice and an opportunity to respond to it. And, the agency thought the person was leaving voluntarily, so of course they didn't give any notice. There wasn't any formal action. Nonetheless, if the employee proves that, in fact, these actions were involuntary, then not only has he or she proved jurisdiction, but he's also proved a due process violation, and the whole case will have to be overturned. So in those instances, the jurisdictional hearing is, in fact, the whole ball game. But in a more typical adverse action case, jurisdiction is a threshold issue to determine whether there's entitlement to a hearing, and many times the board will send out orders to an appellant saying, well, show cause as to why there's jurisdiction here, and if you don't, the case will end and you're not going to get the hearing that you've requested. Now, let's assume that we've gotten to that hearing. One of the significant issues at a hearing could be credibility of witnesses. Who are we to believe? We are third parties, the board, coming to these disputes, and there's often dispute on certain critical facts, and so the board is in the position of trying to decide, who do we believe? Somebody is got to be more credible than someone else for us to render a decision in many cases. So we have recourse to what's called the Hillen factors, which stems from Hillen versus Army. And let me go back to these factors. These are the factors that, and it's not necessarily an exhaustive list, but these are the factors that the board has found to be significant in determining whether to believe one line of testimony versus another. Again, like with the Douglas factors, it doesn't mean that every factor comes into play in every situation. But it's good for you to be thinking about these factors because you can be sure that the judge is going to be thinking about them. And whether the judge specifically cites to them or not, the judge is conscious that in making a credibility finding, he or she is going to have to defend that and explain that to the board and the Court of Appeals. And so these are the factors that the judge is going to look for. Who is in the best opportunity to have witnessed something? What's the character of a witness, or is there any possible bias pro or against one side or another? How does the testimony fit in with other witness testimony or other evidence in the record? Is the testimony inherently improbable? Does it make sense in the way that the world works? Has that particular witness made inconsistent statements regarding the testimony that they're giving now in the hearing about this matter, about other matters? And finally, the question of demeanor testimony, which is an interesting one. Demeanor is typically defined as sort of the carriage, the behavior, the manner, the appearance of a witness. And the idea here is that the judge who is physically present, although these days many times hearings are conducted by video, so it's a virtual presence. But in either case, whether it's in person or by video, the judge has an opportunity to observe those demeanor characteristics in a way that the reviewing courts won't. So on the strength of that, the successive levels of appeal are supposed to give some deference to the trial judge because they were there and they could assess demeanor. In practice, I find that that's probably the weakest grounds for trying to assess someone's credibility because it's often difficult, if not impossible, to decide whether somebody is truthful or not just based on looking at them. And I think it's sort of dangerous to decide, is somebody nervous because they're lying or is somebody nervous because it's nerve-wracking to be on the spot, on the witness stand? And are other people smooth and persuasive because they're confident they're telling the truth, or are they just glib and they have that skill? It may be something that you can comment on whether somebody was forthright or somebody was, wasn't stumbling with different versions of events. But I think in practice, many of the other factors turn out to be more significant and more reliable than demeanor. But it is there in the case law as a significant factor. Mike, want to? Okay. Let me get to the next slide there. The Bornenkopf case touches on another issue that sometimes arises in board cases, and that's the question of how should hearsay testimony be considered. And it's for many people getting the sense of a trial from television or movies, it's customary to hear the attorneys, objecting, Your Honor, that was hearsay. And it's true that in criminal law and in civil law, there's a whole body of evidence on what is hearsay and all the many exceptions to hearsay. Hearsay typically defined as an out-of-court statement that's being offered to prove the truth of the matter asserted. And it's very complex. When you can or can't introduce hearsay evidence. In the board practice, we can cut through a lot of that by just saying that, and as we do say, that whether or not something is hearsay is not a bar to its admissibility. Hearsay testimony is admissible. So it doesn't pay for either side to be objecting on that basis that something is hearsay. However, it may well go to the weight of a particular piece of evidence, and clearly, firsthand testimony, firsthand sworn testimony of an eyewitness is going to be more weighty than hearsay evidence most of the time. But the Bornenkopf case comes up with its own factors as to how much weight a particular piece of hearsay evidence or testimony should be given. It talks about, how much weight should we give a piece of hearsay evidence when there might have been availability of a firsthand witness. So the question of, was there such a person? If that person has passed on or is unavailable for some other reason, that might be reason to give more weight to hearsay than otherwise. Whether the out-of-court statements are sworn, whether the person making the out-of-court statement was disinterested, or dispassionate, or might have had some kind of bias, whether they were routinely made or not, whether there was a consistency of these out-of-court statements with other statements and evidence, whether there's corroboration of the statements or contradiction in the record, the credibility of the out-of-state declarant. A lot of these things, as you can tell, are kind of similar to many of the Hillen factors, but again, it goes to the weight of the evidence, not the admissibility. And just as a postscript to that that John Doe case, the FBI agent who was taping his encounters with his fellow employees, after it was remanded back to the AJ, it ended up being there was a finding of nexus, and the AJ ended up mitigating the removal to a 45-day suspension. Subsequently, the agency removed him again, and they said that the employee number one, the first female coworker, had indicated in the prior appeal that she was aware of the taping, and that and she was his fiancée at the time, and they had some rough patches with the relationship, but she testified that she wasn't upset about it at the time. She was only upset after she found out he had taped other people. Well, subsequently, she recanted and said that the employee had told her to lie under oath about that. And so then they removed him for that. And in the subsequent case, now this employee, this coworker, his ex-fiancée, did not appear at the subsequent hearing. So her statements were hearsay. And the AJ basically went down the list of Bornenkopf factors and found her not credible. There was strong indication that she was not disinterested. She had broken off the engagement, that she may have been biased against the employee. Plus, she had made a number of other statements which were not credible. She said that she had not participated, not known about the taping. You know, initially she said she knew about the taping, then she recanted and said she didn't. But there was actual video evidence in which she was apparently at some points holding the camera. It must have been quite interesting evidence to review. But in any case, there were a number of indications that her positions were inconsistent. She was not a disinterested employee, a disinterested witness. It was not sworn, and the appellant, who did testify at the hearing under oath, said that he had told her about the taping, and that was borne up by other evidence. So based on the Bornenkopf factor, she was found not credible, and that second removal was overturned as well. That's all I have on that. And I guess we're going to go on now to, as promised, some discussion about the defenses to an action. Oh, there is a question. Go ahead.
The deciding official receives a witness statement that was not included in the original evidence file given to the employee. The agency provides the new evidence to the employee for response. Should the employee be given the same length of time as in the original response, which is 14 days, or is it okay to give them less time to respond to the new evidence, about 7 days?
That's a good question. I frankly don't know whether there's a hard and fast rule on that. My guess is that the 7 days. Well, I mean, I don't think that there's anything deficient about the 7 days unless the appellant is going to cite to circumstances that given amount of time prevented him from meaningfully responding. I mean, if there's some intervening circumstances that rendered the 7 days inadequate, then the agency might have a problem. But per se, giving a lesser time for that amended proposal, I don't know that per se is a problem. What do you think, Mike?
Yeah, the statutory requirement is that somebody have a reasonable time, but no less than 14 days to respond to the initial notice of proposal. But the test really is the reasonableness. If it's something that is a major game changer, then it's entirely possible that they'll need more than 7 days to respond. Otherwise, they may, less time than 7 days might be perfectly acceptable. The board wouldn't reverse simply on the basis of the number of days. I don't believe it would be on the question of whether the appellant had a genuine opportunity to respond.
Right, and it may be that the proof might be in the pudding. I mean, if the employee does respond, then that will be in the record, and the board will say, well, it's not clear that the employee's response was inadequate. That, in other words, if the question was, how do you respond to this additional discipline, and if the employee responded to that, whether it was within the 7 days or 14 days, that may be good evidence that he had an opportunity to respond. Now, if he has some specific reason why he needed more time to investigate or obtain additional documentation or something like that, then it might become an issue that it was too quick a turnaround. I don't think that just per se that it was 7 days would be a problem, but it would be fact specific, I think.
Anything else on that?
Nothing else on that, but there are a couple of questions based on this question. Do you recommend doing a Douglas factor analysis in a medical inability to perform action? This is a non-disciplinary adverse action based upon medical condition.
No, I mean, the Douglas factors would really not apply in the same way in a case of a medical inability. It would really be the position description, the duties, and the medical evidence. It's as the questioner says, it's not disciplinary, so it would be that would be superfluous, I think, in that case.
Right. Okay. All right. We're going to move on to affirmative defenses now, from the agency's burden to the appellants, and the way in which the statute that formed the board's authority sets forth affirmative defenses is in 5 U.S.C. 7701, where it says that an agency's action cannot be sustained if the appellant proves either that there was harmful error or that there was that the action was not in accordance with law, or that a prohibited personnel practice occurred. And let's see here, what is it that turns this?
Oh, it's the one on the side there.
The side one. All right. Okay, not being good with technology. Apparently I'm not good with hand-eye coordination either. The case of Stephen versus Air Force is a significant case because it draws the line between each of those three 7701 defenses. Under the rubric of the more things change, the more they stay the same, you're hearing these days that the civil service needs to be changed because it's too hard to take an action against an employee, and when the case is heard by the board, it gets overturned on technicalities. And that was very much one of the large incentives for Congress to pass the Civil Service Reform Act that formed the board in the first place in 1978 and then 1979 when we actually came into being. And the idea of setting out these affirmative defenses was to limit that effect. But over the years, the situation that arose in Stephen was one that we'd seen a good bit, where an agency brought an action against a person believing that he or she was a probationer and finding only that, in fact, they did have adverse action appeal rights. The board would say, as a general matter, as they did before in the early part of Stephen, the AJ's decision, that it was harmful error for the agency not to have given the appellant these procedural requirements, because after all, they were procedures and the appellant didn't get them, and so the absence was more or less automatically considered to be harmful error. The board, however, said, going back to the legislative history of the Civil Service Reform Act, that harmful error is something that you cannot presume. In fact, harmful error has to be proven. And in a lot of these cases, if you're a probationer and you've gotten some sort of notice as to the reason for the agency taking its action against you, and you've been given an opportunity to respond, perhaps you wouldn't be able to prove that the error was harmful in that they didn't give you the entire panoply of Chapter 75 rights. So the board took that as the jumping off point to define harmful error as something that absolutely needed to be proven. That is, that it was some error, either statutory or regulatory, and it also could be within the agency's own procedures, that was harmful. That is, that did have an effect on or could well have had an effect on the agency's decision. They then said that the kind of mistake that the agency made here in giving somebody only the rights of a probationer rather than the Chapter 75 rights constituted a denial of due process. And of course, Ron talked all about what due process requires, and also all of the facts of due process denial arose from the fact that the agency didn't give the appellant all of her rights under Chapter 75 in this case, but it could also be under Chapter 43, or in fact any form of action taken against an employee. The type of problem that is intended to be remedied by prohibited personnel practices is very clear, because 5 U.S.C. 2302 sets out what the prohibited personnel practices are. And finally, an action that's not in accordance with law, the board defined that as an action that does not have any basis under law. So that would be any situation in which an agency took an action without a proper basis in the law for doing so. In other words, trying to, apply Chapter 75 to a contractor, or doing something that would not be authorized by law. It's something that we see very little of course, but it is there in the law, and so you need to be aware of it. The Wren case is the other aspect of prohibited personnel practices. Although an action can be reversed on the basis of a prohibited personnel practice, a prohibited personnel practice does not in itself give the board jurisdiction over the action that the employee is appealing. So the commission of a prohibited personnel practice alone does not give us jurisdiction. So the only way in which we can overturn an action because of a prohibited personnel practice is if we have jurisdiction over the underlying action in the first place. There's obviously a bit of an exception in the case of individual right of action appeals, but we'll get to that in just a couple of minutes. The case that we chose to go along with this, Lachance versus Erickson, is another Supreme Court decision. The Federal Circuit, which is our main reviewing court, and up until the end of 2012 was our only reviewing court after 1984, had held in an earlier case that you cannot charge an employee both with underlying misconduct and also falsifying his response when he was asked about that misconduct. And the board applied that in the Erickson case and in 5 or 6 others at that point that got consolidated with it. And when it went to the Federal Circuit said, well, yeah, this sounds familiar. We issued that first case. It was called Grubka versus IRS. And so we think this is absolutely correct. The employee has the right to deny that he engaged in this misconduct and to make the agency prove its charge. Excuse me. And OPM, who the director at that point, requested reconsideration from the board, the board and the court, excuse me, and ultimately brought the action to the Supreme Court, which granted cert. And in this decision, they said no, that isn't the fact. An employee does not have a right to lie. He can either answer truthfully, or he can choose not to answer and face the consequences of that. But lying is not one of the ways in which an employee can respond to a question that asks whether he committed misconduct. They were quick to point out that if the charge was of a criminal nature, then the Fifth Amendment would prevent the agency from taking any adverse inference from it. But in a civil case, which all of the board's cases are, that isn't true. As long as the employee has been warned that his answers could be used against him, then the employee has to answer truthfully, or simply not answer and see what the result of that might be on his future. But it's a big issue when you think about it, because if you're charged with something, naturally your first response tends to be to deny it. But that can get employees into trouble. And so agencies are not foreclosed from charging somebody with, in fact, lying to them about whether they committed misconduct. So that might be something that agencies should keep in mind when they're thinking about drawing up charges, as Ron talked about. Whoops, I think we went beyond here.
That's it.
Yeah, okay. The next set of cases that we wanted to talk about are the whistleblower cases. Whistleblowing, of course, is one of the very big PPPs, the prohibited personnel practices. And, you know, the flyer that went around to you guys talking about what we were going to talk about said mostly that it was going to be adverse actions in Chapter 43, but we felt that you couldn't reasonably get a full, complete picture of what it is that has been some of the most significant board law without going into a few other areas, and clearly whistleblowing is one of them. I'll try and move along quickly, though, so that we can just give you a brief idea of each one of these. Eunice versus DVA is significant because it is the case that sets out what the burden of proof is. There had been a whole lot of case law back and forth between the board and the court on what that burden of proof was, but what the court ultimately said is that an appellant has to prove by preponderant evidence that he exhausted his remedy with the Office of Special Counsel, but then only has to make non-frivolous allegations as to the other aspects, which are that he made a protected disclosure, as that term is defined by the law, and also that that protected disclosure was a contributing factor to the agency taking a personnel action against him. So, you know, you have the aspect of protected disclosure, contributing factor, and personnel action, all of which the appellant has the burden to prove by preponderant evidence. Once he does that, though, it's up to the agency to come forward with clear and convincing evidence that that it would have taken the action, same action, even absent the appellant's whistleblowing. And clear and convincing evidence is defined in the board's regulations as a very much higher form of proof. You have to have a certainty. You have to be convinced that convincing enough to prove your case. It's not simply that, well, reasonable people could find it. It is that there is some reasonable certainty that what you're saying is true. And the cases that I listed, these Chambers, Greenspan, and Parikh, illustrate how very important meeting that burden is. Chambers, for those of you who live in the D.C. area, you may be familiar with that. because Teresa Chambers was the chief of the park police, and she talked to the press and to Congress about what she believed to be the underfunding of her agency and its effects. And the board initially found against her, but after a back and forth at the court, it ultimately determined that, in fact, her whistleblowing was a contributing factor, and that the agency failed to prove that it would have taken the same action against her had she not, in fact, blown the whistle. In that instance, it looked at all of the evidence in tremendous detail, and what it found was that the agency was sufficiently concerned about being embarrassed in front of Congress by a statement by the chief that more or less indicated that Congress was doing it no favors by underfunding it. And so the board found in her behalf on that. In Greenspan, what the board found, the court in this case found was that the appellant was basically charged with making disclosures. And when an employee is charged with making disclosures, that pretty much meets their burden of proof. And so the agency is going to have to put forth an even more convincing case, is what the court indicated, if the charge itself is that they made a disclosure. And finally, Parikh, I think that's a very interesting case. This was a doctor for the Veterans Administration, and he blew the whistle on his colleagues' performance because he admitted he didn't like them and he wanted them out. The board found that, in fact, the motivation for blowing the whistle was simply irrelevant. And then it went on and it found that the charge was supported and that the agency's primary motive, that means their number one motive in firing him, was the charged misconduct. But then they went on and found that nonetheless the agency did not meet its burden of proof by clear and convincing evidence. And I think those cases illustrate to you the very strong power of the clear and convincing evidence burden. And although some of these cases, when they're brought as IRA appeals, are not cases in which there's been an action by the agency, so you can't reasonably insulate yourself, shall we say, at the beginning of the process, you still have to go and make sure you meet your burden of proof, or else join our mediation program and try and settle the case with the appellant for something less than a complete victory. And then to go back to that McLean case, that one's in here really only because this is the court's most recent pronouncement, the Supreme Court's most recent pronouncement on the board's case law. And in McLean, the appellant was removed for giving out information to the press that was prohibited by as sensitive security information. So it was prohibited by the Department of Transportation to give this out. And the Department of Transportation got its authority to prohibit that information from being distributed by a statute. And the government argued that because of that initial statutory authority, it constituted an action that, information that was specifically prohibited by law, which is the 2302 B8 requirement for it. And the agency then argued that, therefore, it was okay to remove him. The board agreed, but the court disagreed. And it's really just a statutory interpretation kind of case. But honestly, I'd have to say I think the court reached the right result there. I think we'll be seeing fewer of these cases in the future, but it is a very significant case.
Let me just a couple of comments about whistleblowing. I mean, going back to discussion about rights to a hearing, in these whistleblowing cases, often the administrative judge has to make a fateful decision early on as to whether the appellant has made those non-frivolous allegations of jurisdiction, thus entitling them to a hearing on the jurisdictional question. I'm talking about when it's an IRA case where there isn't an otherwise appealable action. So, for example, if somebody said that they retaliated against me by failing to promote me or reassigning me, we wouldn't normally have jurisdiction. But if they allege the whistleblowing IRA jurisdiction, the board would have jurisdiction. And there's, as Mike was pointing out, there's all these complicated elements of jurisdiction. You know, was there a protected disclosure? Was it a contributing factor to the personnel action? Was there even a personnel action? Because not everything qualifies. And if the administrative judge finds that there wasn't a non-frivolous allegation and dismisses it without a hearing, the successive levels of appeal may find that, well, maybe the appellant won't be able to prove this, but he or she should at least have had a hearing. Now, the standards for finding whether there was jurisdiction, whether there was a non-frivolous allegation, have changed quite a bit because of the passage of the Whistleblower Protection Enforcement Act, which was motivated in part by Congress's dissatisfaction with some decisions from both the board and the U.S. Court of Appeals for the Federal Circuit. The Federal Circuit had found, for example, that disclosures that would otherwise be protected that were made in the normal course of an employee's duties did not qualify as protected disclosures. Or if they were made to the alleged wrongdoer, the alleged retaliator, that was not a protected disclosure. And so those cases were being dismissed prior to a hearing. So one of the main focuses of the WPEA was to say that those kinds of disclosures will not be disqualified simply because they were made during an employee's normal duties or during the normal, made through the normal chain of command or to an alleged wrongdoer. And the WPEA made a number of other changes too, which has the overall effect of making it more liberal for a finding of jurisdiction and more likely that a hearing will be held in these cases.
Yeah, over the years, you can see a gradual ramping up of the whistleblower protections. I think it's clear from both the law itself and from its legislative history that although Congress may think that most of us federal employees are worthless, they clearly like whistleblowers. And so when you're in the position of defending a whistleblower case, it does put the agency in a difficult place. Moving on to Chapter 43 cases, Chapter 43 was another invention of the Civil Service Reform Act, and Chapter 43 was viewed as the best way for an agency to take an action against somebody due to unacceptable performance. The idea of Chapter 43 is based on performance evaluations, and it's quite clear when you read Chapter 43 that performance evaluations are supposed to be the basis for any number of things, not just removing an employee or demoting him, but also rewarding an employee, promoting employees, giving them training, all sorts of things that might normally relate to performance. And so as a result of the passage of the Civil Service Reform Act, several years later, the board issued a number of decisions, and these five in this and the next slide are the big cases. The board's cases, Schuman and Sandland, are significant because they set out the requirements under Chapter 43. In the case of Schuman, for an agency that chooses to write its performance standard so that it includes a lot of different elements, and then to remove the employee for failure of less than all of those elements, the board there said that You can do that, but you have to prove that failure of those particular elements constitutes failure of the entire element as a whole. In Sandland, the issue was, well, if an employee is entitled to an opportunity to demonstrate acceptable performance before he or she is removed, if I don't, as an agency, give somebody a full opportunity to do that, isn't that just a question of harmful error? And the board said, you might think so, but we're deciding that it's not, that in fact it is a substantive right, so it is not subject to a finding of harmful error, and in fact it is something the agency has to prove. That being said, the board has never in all of these years said that an opportunity to demonstrate acceptable performance has to include any particular kind of assistance. Under most circumstances, allowing the employee to perform in his or her job is a sufficient opportunity to improve. But of course, giving the employee assistance is generally considered to be appropriate. And under the circumstances of any given case, if the agency refuses to do that, it does so at its own peril. The Donaldson case is the case that deals with what valid performance standards require, and the case is significant because it talks about a sort of a spectrum of specificity. That is, that an agency can be less specific if the job requires more professional kind of discretion on the part of the employee performing it than it could be if the job was more or less repetitive and rote. In defining performance standards for an employee, the board recognized that it's a very difficult thing to do, and particularly difficult to do it right. But what the board said is that you have to give people enough information that they have a firm benchmark at which to aim their performance, and not simply some sort of an amorphous goal that the agency can sort of move the goalposts depending on whether it likes you or not, further away or closer. The Lisecki case is one that simply says that the board has no authority to mitigate a Chapter 43 action, and that is one of the trade-offs. The agency has a much lower burden of proof in a Chapter 43 action, but it does, in fact, get a lower burden of proof. So that is one of the trade-offs that Congress was willing to make in Chapter 43. The final one, Lovshin versus Navy, the board, based on the legislative history, found that Chapter 43 was intended to be exclusive, the only way in which an agency could take an action against an employee for unacceptable performance, but the court disagreed and said Chapter 75 still exists. And so that can be the basis for a performance action, as you know, and the fact is that most of performance actions that we see on appeal are done by via Chapter 75, and there are a whole set of rules that apply to those kinds of actions as well.
It's kind of an irony that I think, as Mike was saying, I think Congress came up with the Chapter 43 actions to make it easier for agencies to discipline poor performers. But as Mike was saying, I think most of the time agencies are choosing to take these actions under Chapter 75, even though there's the higher burden of proof, because there's fewer hoops to jump through. You don't have to put people on a PIP. and show that you gave them an opportunity. You don't have to get into the quagmire of what's a valid performance standard, and it seems as though often agencies are willing to forego the lower burden of proof, the substantial evidence burden, because they don't want to go through the protracted PIP process and all the other things. But
okay. Okay, let's move on to RIFs and furloughs. There's a whole lot of law on RIFs and very little on furloughs up until last year. Our AJs were chagrined to find. But the cases that we've chosen on these topics are really very significant lead cases. Lozier versus ICC is a case that stands for the proposition that an agency cannot take a reduction in force action against an employee on the basis of any kind of personality issue. The facts of the case showed that Ms. Lozier was doing an excellent job in her congressional relations position, and that, however, that her two bosses were really cheating on things and committed gross misconduct. So the two bosses were fired. The agency decided, well, they better clean up their act, so they reorganized the office, and because she was the third member of that office, they fired her, they RIF'd her as well during the course of this reorganization. The board's finding was really the reason that they wanted her out was not that her performance, not that her job was unnecessary, because in fact the job continued under a different title, but because of her association with these other folks. And they found that that was an abuse of the agency's discretion, and therefore that the action couldn't stand. So really it stands for the proposition that it has to simply be based on one of those reasons given in Part 351 of the regulations, shortage of work, shortage of funds, reorganization, those kinds of genuine bona fide determinations. And Chandler versus Treasury, we hope this won't be very common, that we'll have to be referring to this in the future, but that was the board's first and most significant case on the 2013 furloughs. It basically says that the board will examine the agency's action just to be sure that it promotes the efficiency of the service. The board will not substitute its judgment for the agency with respect to decisions about how it should spend its money, with respect to who should be furloughed and who shouldn't be. Those kinds of things are left to the agency's discretion. The big point is just that the agency has to do a furlough in what the board called a fair and even manner. The next topics we don't have time to go into in detail, but USERRA and VOA are subject matters that, like IRAs, allow an appellant to bring an action even if the agency has not proposed and effected any particular action. As I'd like to say, if either of these were a stock, they would be the board's growth stocks, because over the years, the numbers of them have grown exponentially, and we're getting quite a number of them. The deal with USERRA, the Uniform Services Employment and Reemployment Rights Act, is that it has two parts. You can bring an action based on discrimination, claiming discrimination against you because of your military service, or you can bring an action that says, after I left military service, I tried to be reemployed with the government because I left the government in order to go into the military, and those cases are also heard. In a discrimination case, the appellant has the burden of proving that the agency took its action specifically because of his military obligations. In a reemployment case, intent is totally irrelevant, and it is up to the agency to prove that it did not violate the law. So those are the significant issues in that case, in USERRA, and the Macmillan and the Macmillan case, goes slightly beyond your basic discrimination case because it addresses an action taken not because the employee was in the military alone, but because of what he did in the military. And the board found that that could very well be a basis for a finding of discrimination. The VOA cases, these are ones where an appellant claims that his rights under a statute or a statute that relates to veterans' preference were violated. And in those cases, the appellant has the burden of proving that that happened. The next aspect that we wanted to mention, just to point out to you, were the security clearance cases. Department of Navy versus Egan is the big case to know. It basically says there's no right to keep a security clearance or to get one, and therefore we, as the board, have no authority to review whether an employee should have had one and can be fired because of it. Kaplan versus Conyers adopts that same kind of rule for purposes of sensitive positions that don't necessarily require a security clearance. And then the last topic we wanted to mention was attorney fees. The Allen case sets out the board's basic rules for what constitutes the interest of justice. The statute requires that an attorney fees award be given when fees are incurred, when the fee is reasonable, and when payment of it would be in the interest of justice. This case is the lead case on defining those terms. Crumbaker is a case that just sort of goes beyond that in talking about reasonableness. So the agency, it's up, the burden, the important thing for the agency to remember in Crumbaker is that the agency has the burden of opposing specific aspects for specific reasons of an appellant's attorney fees claim. And if they don't do it, then the board has to impose some standards, but is less likely to find against an employee. And then the last one is the Sacco case. And in that one, that is a change in the law that allows agencies actually to escape paying attorney fees by simply recognizing that they're going to lose. And when they do, by then simply mooting out the case by giving the appellant, putting the appellant back to work, you don't get attorney fees for that. The only option that the appellant has, though, is that if he has raised a claim of discrimination or another affirmative defense, that will not moot out the case. But Sacco isn't a significant case for you to know about. And I see we've reached more than the end of our time, so we thank you very much for your attention, and we hope this has been helpful for you.
Mr. Bogdanow and Administrative Judge Weiss, thank you for sharing your expertise during today's roundtable on MSPB case law. Your presentation has provided an exceptional overview of the developments in federal case law. I thank OPM's communication staff as well for your webcast of this roundtable. And a very special thanks to my staff for your work in coordinating the roundtable. Thank you for participating today, and we look forward to having you at the next Employee and Labor Relations Roundtable. Finally, Please remember that shortly you will receive an email with a hyperlink to an online evaluation form, courtesy of SurveyMonkey.com. Your feedback helps us to plan future roundtables, and we appreciate your taking the time to complete this survey. Have a good afternoon.